This hearing will come to order. We have two panels today to examine the National Flood Insurance Program's claim process, particularly how it was administered in the aftermath of Superstorm Sandy. This is in response to the hundreds of letters, emails, and phone calls I've received from desperate homeowners looking for help. And so let me thank our first panelist this morning when he gets here, FEMA Administrator Fugate, for being there to shed some light on what we must do to fix the process and make sure that it is a fair process with clear guidelines for homeowners in my state and around the country. Through their circumstances, and though their circumstances after Sandy may have varied, their stories follow a common thread. They did the responsible thing. They faithfully paid for flood insurance for 10, 20, or even 30 years. They never had a claim until Sandy devastated their houses, only to find out it wasn't enough. They assumed, since they had insurance, that they would be made whole and have the resources necessary to rebuild. They survived the wind and the rain and storm surge, only to face another nightmare, a flood insurance claim process that threatened to take what the storm had not. One of my constituents, Doug Quinn, who is with us here today, who I had the pleasure of meeting on Monday, said that when he contacted my office, he said, quote, "I was in my home the night the floodwaters rushed in. I waded out through waist-deep water at midnight to escape while electrical transformers exploded and houses burned down. That was the easy part. It's the year and a half since then that has been the tragedy." Doug had maximum coverage of $250,000 and received estimates of up to $254,000 in damages, but he only received $90,000, a third of what he needed to rebuild. And Doug is not alone. The fact is, the entire claims process, from the initial filing to the way claims are processed to the appeals process, is tilted against homeowners like Doug. Another constituent of mine, Steve Pisciano from Ortley Beach, appealed his settlement to FEMA, but after repeatedly inquiring about its status, FEMA finally acknowledged it sent a response to the wrong address. A couple from Kingsburg was only able to recover $21,000, even after a public adjuster confirmed there was more than 4 times that amount, or $87,000 in damage. When the couple tried to challenge the settlement, they were repeatedly told their case was closed. Underpayments and overly complex requirements, the runaround from FEMA on the appeals process, arbitrary, inflexible deadlines, overuse of highly technical exemptions, all highlight a program that, in my view, clearly needs improvement. While FEMA, of course, needs to protect taxpayers and prevent waste, fraud, and abuse, it is also necessary to protect policyholders and ensure that they are treated fairly. The question is how we strike the proper balance between protecting taxpayers against overpayments while not systematically shortchanging hardworking families who played by the rules. I think we should all agree, and I would hope Administrator Fugate would agree, that the process needs to be made fair. Homeowners want to know what common sense reforms FEMA can make to stop focusing disproportionately on overpayments while neglecting to protect qualified homeowners from being lowballed and unable to rebuild. We need answers, and I hope this hearing will help us get there. Hope our witnesses will address the issue of homeowners in New Jersey, and I'm sure elsewhere, who have had to threaten litigation just to get their insurance company to make them whole in time of disaster after they've paid their premiums and played by the rules. Affordable, accessible, and robust flood insurance is critical to the prosperity and economic future of my state and every state that suffers the effects of a storm like Sandy. The stakes are simply too high to get it wrong, and I look forward to hearing from the administrator and from our second panel on how we can absolutely be certain we get it right. Thank you. Let me go over a series of things, and I'm glad to hear that you've asked the Inspector General to look at the program, because I think the program has significant faults, as I've experienced by listening to a wide range. You know, I have, after 40 years of public life, I have a basic philosophy. If I hear one person complain about something, maybe they're just not happy. If I have 2 or 3 people complain about it, maybe it's a coincidence. When I have hundreds complain about it, something's wrong. So tell me, what is the penalty for a write your own that makes an overpayment, meaning it pays a flood insurance claimant too much? Can you put your microphone on?
Sorry, Senator. They have to reimburse the flood insurance program at the determination that there was an overpayment.
And what happens if FEMA determines that a write your own has made an underpayment, meaning that it pays a flood insurance claimant too little?
Then we have to go back and pay the claimant the difference of the underpayment to what was actually owed. And we also look at the record and percentages that write your owns have of over and under payments. There is a review board made up of write your owns and FEMA staff that would then look at that and see if this is a pattern. Is it in excess of what we would expect to see as an error rate? Is there underlying trends, and what remedial actions may be taken to address that, whether it's further training or other sanctions?
So write your own can be threatened with being thrown out of the program for a pattern of underpayments, but there's no direct tangible monetary consequence like there is for an overpayment.
Well, again, with the overpayments, when they have to pay that back, then they have to make a decision whether they absorb that cost or seek that back from the person they paid to. It's not in their interest to get this wrong, because it is for them, for public relations purposes, just as negative if they have to go back and seek money back. And the losses to them are based upon that, as well as having to pay back the flood insurance fund.
Well, but a write your own would not have to pay the difference it had underpaid a policyholder in the same way it would have to reimburse FEMA for an overpayment.
Again, Senator, the flood insurance program ultimately makes the payments, and if there are overages or underages, it has to be made up in the flood insurance program. So the write your owns are a conduit, but if you overpay, that has to come back into the flood insurance. If it's an underpay, it still comes out of the flood insurance. The write your owns get percentages for handling claims, but the actual payments is basically the flood insurance program. Overages and underages have to be balanced out in that account.
Well, my point is there are no direct monetary penalties for a write your own that makes underpayments. I understand the overpayments. The only action that FEMA takes with regard to underpayments is to conduct more audits if the improper payment rate reaches 20%, and then potentially kick out the write your own of the program if the problem continues. So if that's the case, let me ask you, in the 40 plus years that the National Flood Insurance Program has been operating, how many write your owns have been thrown out of the program due to repeated patterns of underpaying claims?
I'm not aware of any, Senator.
Okay. So if there are none in 40 years, either they're doing an exceptional job or we are not doing a particularly good job of conducting the type of audit and doing the type of metrics and information to determine whether there are underpayments taking place in a systematic fashion. If an insurance company pays a claimant too much money, it's on the hook for every dollar it overpaid. While at the same time, if an insurer pays a claimant too little, the penalty is in practice non-existent. So to me, in terms of incentive, this structure clearly seems to influence the write your owns to be more conservative when adjusting for claims, which leads to policyholders being lowballed.
The response to that, Senator, is, again, part of what we want to look at is that the trend, but the other part of that is they're paid a percentage of the total claim. So if they're underwriting, then they're actually reducing what their reimbursables are. And again, these are rather expensive policies to service. So I'm sure the write your owns want the right balance, that they're not underwriting claims unnecessarily, because the penalty then, again, is based upon their reimbursables for the expenses of doing the program.
Let's talk about that quote-unquote incentive. The reality is that the write your owns actually have had the amount that they would be paid on commission cut to less than half of what it was prior to 2009. So they used to get 3.3% commission. That number was reduced to 1.5 in 2009, which further diminishes their incentive to make the settlement as full as possible. And when you compare the incentive to the threat that the Write Your Own faces of an overpayment punishment, this drastically reduced commission is dwarfed by the threat of clawback and overpayment punishment. And so, look, I don't want anybody to be overpaid. I want to safeguard the taxpayers' money. But I don't want anybody to be underpaid, paid less than what they're due. You weren't here for my opening statement, but one of my constituents who sits in the audience, even at actual cash value, received clearly far less than his actual cash value damages. And so his story is a story that is replicated by literally hundreds of others in our state. So we've got to get this set of balance right. And when the insurance companies basically say, well, if I get in a position where I'm considered overpaying, I'm going to have to pay that back, versus if I am far more conservative and underpay, I don't have the risk. If there's an error to be made, I'm going to make it on the side of underpaying, not overpaying, because at the end of the day, the consequences to me are greater than the incentives are to me to do the right thing. And so we've got to find a way in which we can create the right balance, because there's a reason that the statute treats underpayment equally. It doesn't say that it's less important than overpayment. It says it's to be treated equally. And that is not what is happening. I have a series of other questions, but we have colleagues here, so let me turn to them.
Thank you, Mr. Chairman.
Thank you, Senator. Let me ask you, Administrator, the Flood Insurance Reform Act of 2004 established a appeals process and required FEMA to respond to appeals within 90 days. Did FEMA comply with this requirement in the months after Sandy?
No, sir. We exceeded that, and we had to beef up and bring in more staff and grow that program to handle the caseload. It wasn't until, I believe, January this year that we cleared that backlog and are currently meeting the requirement to be within 90 days or less.
How many appeals during this window were not responded to?
Off the top of my head, Senator, I'd have to respond for the record. It was in, I believe, more than the hundreds. I think it was in the thousands, but I don't have a specific number.
We've asked this question and we're told that you don't track this data. If that's the case, that you don't track the data on the program, it's necessary to understand how it is or is not working. And if you don't track this information, I don't know how exactly you know there's a problem until it gets so big that you realize there's a problem. And if you track the information, it would give you an opportunity to intervene earlier in the process before you have a problem. But one of my big problems here is the consequences, right? So the law says it's 90 days. And if you fail to comply with the law, then leaving disaster victims in limbo for months isn't only bad enough, it also jeopardizes their legal rights. Because FEMA is arguing in court that the 1-year statute of limitations for lawsuits begins when the Write Your Own creates a first denial, not after the appeal process is complete or a proof of loss is filed. Now, an average citizen without a law degree, they're going to assume that they should wait for the appeal to be completed before they go ahead and file a lawsuit. So while disaster victims are waiting 4, 5, 6 months or more for FEMA to rule on their appeal, the window for their legal rights is quickly closing, especially a person who isn't versed in the law, which actually creates, I'm not saying that you do it, but it creates potentially a perverse incentive for FEMA to delay so that appeals are reduced in terms of the number of lawsuits.
Senator, we have no incentive not to pay claims. The normal time to file your claims is within 60 days of an event. We've expanded that to 2 years. We're trying to, as many cases as we can, address the backlog of appeals. The statute of limitation case which you state, quite honestly, is what the attorneys have determined working with justice, but that does not preclude a judge from determining the statute of limitations doesn't apply in this case in these lawsuits. But in most cases, I'd rather get the cases resolved and not have to wait for legal
Let me
remedy.
just say, you may not say you have an incentive, but at the same time that FEMA is not meeting its deadlines under the law, it is strictly imposing deadlines on policyholders. In fact, 270 claims were summarily rejected because the policyholder, who had suffered through the second largest natural disaster in our nation's history, missed one of FEMA's imposed deadlines. So we have the ultimate hypocrisy and double standard here. You don't have to live under the deadline, and there's no consequence to you for, not you personally, no consequence to the agency for not meeting the deadline, but there is a consequence for the policyholder for not meeting the deadline. That's when people think poorly of their government.
I understand, Senator. Direction would be appreciated. But I also have to operate within the regulations of the programs, and where I can, we are trying to get these cases resolved and settled.
Well, the regulations under the program, the law, which supersedes regulations, says you have to respond in 90 days. Do you think it's fair that disaster victims were forced to comply with FEMA-imposed deadlines while FEMA fails to comply with its own deadlines?
Again, Senator, with the claims and the number of appeals and staffing that up, we didn't meet the deadlines.
I hope you'll look at those 270 cases that you, from my perspective, arbitrarily and capriciously decided they didn't hit a specific deadline, so therefore, you know what, you're closed, but we get to go ahead and not respond, and not only not 90 days, 120 days, 150 days, some cases that we have in our 180 days before you all responded, and then no consequence to you, but consequence to the policyholder. That's fundamentally unfair. Do you let me ask you, do you track the percentage of appeals that are overturned in favor of the policyholder?
Not that I'm aware of, Senator.
Well, if you don't track that, it seems to me that that's information that's critically important to determine whether the claims process is working efficiently. I mean, I think there's a high successful appeal rate is a red flag that initial claims adjusting is flawed, which would give you the wherewithal to say we need to do something here. But in the absence of knowing that information, there is no drive to be able to deal with it. Let me ask you this. What about the new that we put in the law on Bigot's Waters, a flood insurance advocate? There are people who have no idea that, number one, they have an appeal process. And those who do engage in an appeal process, who have never had to file a flood insurance claim, go alone through the appeal process or litigation and need help to navigate the process. Our flood insurance bill created a flood insurance advocate. And we're trying to convince you at FEMA that this position should help policyholders with filing claims and appeals, in addition to questions about the policy itself and mapping. Is that something that FEMA will consider? And if not the flood advocate, is there any entity at FEMA for helping policyholders go through each of the steps of the appeal process?
Senator, my staff basically didn't want me to go a lot of details about this because they're still formulating it, but I said, I don't agree. I think we have to make this, since this is an advocate, how do we create them as an independent office, not part or subservient to the flood insurance program? I don't think they should be limited to just looking at map disputes. I think on a day-to-day basis, we have to have an advocacy office which provides the basis to look at the customers and represent the customers and issues dealing with that. But in a Sandy-like event, that office would be too small. So how would we expand that capability during those kind of events? So I'm looking at this as an advocate for the consumers, not for any one section or write your own, or only to limit itself to map issues. So we're looking at how to structure that. Senator, I do appreciate the fact that this came after the President's proposed budget, and you have through the Senate and the House provided funding to establish this office. That's a key step in moving forward, since this will be a new initiative as we go forward into the future budget. But it is something that I'm very serious about, that I want this office to be the voice of the consumers and be the focal point for consumers for all flood insurance issues and not limit it to just maps.
Well, look, I hope that ends up being the case, and I agree with you with what your perspective is as to what the advocate should be. I also hope that we get a better data management system, because I think that is critical to be able to know the consequences of lowballing individuals, even under current value, that is taking place. Certainly, we have hundreds of cases in that regard. And I think that without the data management, you can't make intelligent decisions. And I know that you are very capable of making intelligent decisions, but you can't make intelligent decisions if you don't have the information on which to do it. Senator Schumer, would you like to?
Thank you, Mr. Chairman. First, I want to thank you, Mr. Chairman, for your diligence and partnership on Sandy 8. Our states are recovering and recovering well, in good part because of your leadership, and I would like to thank Senator Booker for his leadership on this issue as well. Our New York, New Jersey delegation, Senator Gillibrand and myself, work great with you guys. I also want to thank Administrator Fugate. I think FEMA's done an excellent job overall. There are things I disagree with, obviously, but an excellent job overall in helping us with Superstorm Sandy. In fact, just yesterday, we were able to announce that NYU Langone Hospital would receive $1.13 billion from FEMA to recover the damage. We worked well together. It's a new way of doing things where they get the money more up front. They don't have to have 30 different applications, and that's because of the good work of FEMA. So now that you know I've praised you, you know I'm going to have a point that you won't particularly, that's not a positive one. I have a serious point of concern related to flood insurance claims that have come straight from constituents on Long Island and New York City. I must raise it to your level. I'm doing this in concert with Senator Gillibrand, who I know has talked to you about this as well. She's not on this committee, and so I'm asking the questions, but it's from both of us. It appears that a select few attorneys hired by write-your-own insurance companies and paid by FEMA are cashing in on the backs of struggling homeowners. There are still many homeowners trying to resolve their home insurance claims and receive compensation for their losses. I have learned that for each day a homeowner in New York waits to settle their claims, there are attorneys benefiting from dragging these cases out. These are attorneys hired not by FEMA but by insurance companies for policies underwritten by flood insurance, and it appears they're using legal tactics to prevent homeowners from being paid back for their losses. I don't intend to be critical of you, Administrator Fugate, but because FEMA underwrites the write-your-own policies and pays the legal expenses, I want to raise these concerns to your attention and consider what can be done to spare homeowners from the grips of overly litigious attorneys who have no incentive to try and resolve matters. In fact, they may have an incentive to stretch it out. They get more hourly fees, and the homeowner is there unable to deal with the issue. So, these are my questions, and I'm going to ask my entire statement go in the record. But we've been told that attorneys for the write-your-own insurance companies are drawing out the legal battles with homeowners in an effort to drive up billable hours. The kicker is that the write-your-own insurance companies are not even paying the legal bills for their attorneys. You are. FEMA is. So let me get into my specific questions here. First, given all of what I've mentioned, and I've read in a letter that Defense Counsel representing write-your-own companies before the Eastern District of New York filed with the court on June 18th that the current prediction of the costs from Sandy is the total defense fees from just this one event are likely to exceed the total defense costs incurred by NFIP for all flood insurance events for the previous 20 years, that FEMA's legal bills might exceed $25 million. There was a letter saying that in the Eastern District. So given all of that, first, will you perform an audit of the write-your-own insurance company's legal expenses and implement internal concerns for two reasons, twofold? One, to make sure that FEMA is not overpaying. two, to make sure that homeowners aren't stuck in lengthy legal battles and taxpayers are not reimbursing companies for excessive and inappropriate litigation costs.
Senator, I went one further. I turned this over to the IG. I have enough concern that I've heard too many pieces of this of what does not appear to be what the practice was supposed to be. We provided additional guidance to write your owns, what we think are going to be acceptable legal fees. We have made it very clear that if there's fraud alleged, it should be referred to the Justice Department. If this is an honest disagreement over what is eligible versus what the right your owns are, I'd much rather look at the administrative remedies versus the court cost. But in any case, based upon concerns that when I heard the issues being raised, it hit the threshold that something doesn't sound right. I'm not sure FEMA has. We do not have any investigatory authorities. That's only vested in the DHS IG. So we've asked the IG to take a look at this.
But something smells wrong to you. We're not saying that there's something is wrong, but it's worth investigating for
I've
sure.
heard from too many cases concerns that I cannot answer myself, and since I am not empowered to conduct investigations with outside parties, I've asked the department's inspector general to take a look at this. We've also provided additional guidance back to the right your owns on what we think are adequate defense of these. But again, our goal is if we think it's fraud, it should go to the Justice Department, but we should not be just litigating as a delaying tactic to not pay claims.
I've heard, and if the chair will indulge me for just a minute more, I've heard that there are situations where the litigation costs exceed the cost of settlement. So first, are you aware if this has happened? And second, shouldn't there be some rule that that shouldn't be?
Again, these are things I've heard, Senator. That's why I've asked staff to reach back out to the right your owns. And again, this refers back to the administrative remedies. If there's opportunities to settle, I want to take all the administrative actions versus protracted court cases as a remedy here.
Right. Now, as part of the flood insurance bill that was passed, there was language that would allow homeowners to receive credit for partial mitigation. This is a separate question, really, right? I'll submit that one in writing because I know my colleagues are eager. But I would urge you to do the strongest possible oversight. Something really seems wrong here. We need it checked out. Lawyers, insurance companies taking advantage of homeowners and taking advantage of the U.S. government and FEMA's payment system.
Again, Senator, I know of no actual wrongdoing, but I have concerns, and because I don't have the ability to do these types of investigations, I've asked the DHS IG to look at this matter. Thank you very much.
Thank you. I have one more question. I thank the chairman for his indulgence. I've been told that there is only one attorney who does all of the litigation for the right your owns, which would mean his billing is, if it's $25 to $50 million in expenses, is him to boot. I've heard he's from New Orleans. First question, is that true? Second, what is the mechanism for selecting the attorneys? Is it totally up to the insurance companies? Do you oversee it? Do you have any say in it? And should that change?
Again, Senator, without getting into too much detail, since I've asked the IG to look at this, those are my understandings. Right your owns do select their attorneys. Oftentimes they use attorneys that have had experience in this before. So obviously after Katrina, there was a lot of claims down there.
There's only one?
I do not know that for sure, Senator. That's again why I've asked the IG to
That's what I've been told.
Again, I've heard this, and that's why I've asked the IG to look at this and determine if that's the case and what's going on.
You've heard that there might be just one
Yes,
doing
sir.
it all.
For the majority of the cases, yes.
Right, I hope you'll look into this. Changes we may need to do regulatorily or statutorily. The IG is looking into specific.
Yes, sir, Senator. And this is what I've asked the IG. I've asked them for both looking at this to determine what's going on and also make management recommendations of how we should put in. And that's, again, one of the functions of the IG is not just to find fraud and waste, but to help us invoke management so that we minimize that and get the value and the programs delivered the way they're supposed to.
Thank you. Thank you, Mr. Chairman.
Thank you. Mr. Minister, we have a vote going on. Let me make 4 key points to you. And we are either going to get a administrative response or we're going to get a legislative response. I prefer that it be an administrative response so we can work together, but if it has to be legislative, so be it. We have a standard in my view, that is stacked against a process and a standard that is stacked against policyholders. There are uneven penalties for underpayment versus overpayment. There are uneven incentives as it relates to underpayment versus overpayment. I don't want anybody getting a dime that they shouldn't get. By the same token, I don't want a policyholder who's done the right thing for 10, 20, 30 years in some cases, getting lowballed simply because the process is stacked against them. So we've got to figure out a structural effort to create a greater balance. Secondly, if the policyholder has to live by deadlines, so does FEMA. And if FEMA can't live under those deadlines, then the policyholder should have the opportunity to have the same period of time that you can't live by extended, so that they don't have their rights foreclosed. I think to have the expectation that an average citizen is, Perry Mason is totally unacceptable. And so, I think there's a double standard, and that's not a double standard that we should have. Disaster victims already have enough challenges as they deal with this question. Number three, we got to get this data, help you get this data system running, because we can't know, and I don't know how it is that claims, the numbers of those who are appealed, the numbers who successfully appeal, the numbers that litigate and successfully appeal. I can't tell the size of this problem and whether there is a systematic problem or just an occurrence problem. We need to get that. We need to get that straight, and we need a flood insurance advocate who not only is dealing with the immediacy of rates and flood maps, but is an advocate as to the totality of what happens to someone in flood insurance. And I think in that, hopefully, we are in agreement listening to your comments. It's just simply wrong from my perspective that we have a system when not one Write Your Own in 40 years has ever been kicked out of the program because they consistently lowballed policyholders. Now, maybe they're all doing a great job, but every time I hear these hundreds of cases, I think something is wrong. So we'll look forward to working with you. I do want to applaud you in the aftermath of Sandy. You were on the scene. You were engaged. Your people were fantastic. But once the storm went aside and the immediacy, this program is what for a lot of people is their lifeline. The difference between being able to get back in their homes and not being get back in their home. Doug Quinn, who is one of my constituents, is a Marine. He served his country honorably. He did the right thing. He paid his policies. He didn't ever make a claim until Sandy came along. To step into his home as I did this past Monday, and to see that now, so much time after Sandy, he still can't live there with his daughter, is just not acceptable. Not acceptable. So I hope we can work together to make this right. In the absence of that, we'll see a legislative response to it.
Senator, as I owe you, I'll do as much as I can administratively, and when I hit the walls where the attorneys tell me I can't go any further, I will communicate to you that I've hit a wall and I need your help.
If you need legislative responses, you let me know, and we will be deducing our own. But if you need legislative responses, I'm always willing to pursue it. We've got to make this program right.
As you helped us with Biggert Waters, when you asked me the question and I told you I hit the wall, you were willing to step forward on what had to be done to change that law. So again, my history is when I can't get to where you think I need to be, I want to let you know. We may not agree to the reasons, but if my attorneys or my programs are not able to go any further, I need to be upfront with you that I don't have a way forward. It may require legislation. But as much as I have the administrative ability, I will continue to work.
We are ready and able and willing to go, and we will do so if you bring us information, or in the absence of seeing a change that creates a greater equity in this process, we will do it ourselves. With the thanks of the committee for your appearance, for our next panel, we have 2 votes, one that's just ending, then another one immediately, so it should be back in 10 minutes. This hearing is in recess, subject to the call of the chair. FEMA is trying to throw out many New Jersey lawsuits based on the statute of limitations rather than getting to the merits of the case to see whether there has been lowballing. And FEMA takes the position that the clock starts on the statute of limitations when the homeowner receives any letter saying the word denial, even if the policyholder has not yet submitted a proof of loss form. Don't you think that a completed claim requires a proof of loss form?
I do think that a completed claim requires a proof of loss form. There can't really be a claim if the insured hasn't submitted a proof of loss form. There's no way to really deny or even approve the claim. And the current scheme sets up so many barriers to effective processing of appeals, and particularly for low and moderate income clients, they don't often have the resources to actually even have an attorney to help them with the case or help them with submitting proof of loss, and they end up at a significant disadvantage.
And don't you think that it's ridiculous for FEMA to argue that the statute of limitations can run even before the homeowner has ever submitted a proof of loss?
It doesn't seem to make sense that the statute of limitations would run before a homeowner submits a proof of loss.
Well, I appreciate both of your testimony, because what I've come to believe is that structurally the system is stacked against policyholders. And when the risk for an insurance company is greater for overpayment than any real consequence for underpayment, well, that dictates to me what's going to happen when it's not clear-cut. And even maybe where it is, it's the incentives are on one side of the ledger and not on the other side of the ledger. I think that there's a clear problem with the appeals process, one, for people even knowing about it, and two, for being able to navigate it and understand it. Three, I think that if you have to live by a deadline as a policyholder, FEMA should live by its deadlines as policyholders. As the overall under the statutory provisions of the law that say that they need to be able to respond in 90 days, or if not, there should be some extension. It's pretty ridiculous to toll the statute of limitations before there's even a proof of loss. I haven't practiced law in a while, but there are some fundamental principles that don't take a rocket scientist to figure out. These elements in which in 40 years not one right your own has been ultimately taken out of the program for underpayment is just beyond the scope of imagination. Yet I'm sure that there are those who, with overpayments, have faced that consequence or a consequence of some significance. So we need to change this. And I have to be honest with you, I appreciate legal services and everything they've done. But my God, we shouldn't have to have people go to legal services to work this process. Or in the case, I don't know, do you have to have income qualifications in this particular program of legal services?
Through our Hurricane Sandy Legal Assistance Project, we have a varying kind of income eligibility qualification, and fortunately, due to the funders that I mentioned earlier, we're able to assist just about any client who comes to us for assistance with a flood insurance issue.
That's good to hear, because I know normally legal services has some type of income criteria. But the bottom line is that this is about real people, real lives, real families who do the right thing. They pay their premiums. They follow the rules. They obey the law. And when it comes time when they have a need, you don't have the law actually living up to their expectation and their needs. Now, I understand about current policy value, but that doesn't dictate the results we are getting in so many of these cases. We are getting far below current value realities. And I think we have to do a better job of educating the public about what these policies mean when people are buying them. Now, in some cases, they have no choice. If they have a mortgage company insists on having flood insurance policies. But at least they should clearly understand, for those who have to get flood insurance as a result of holding a mortgage, or for those who don't have a mortgage, they should understand what the flood insurance policy is and is not going to pay. And I don't think people get to read the fine print in a way that makes it very clear. I think that there's some very clear, statements up front that can be made that people will understand the nature of what their policies are. So we need to ultimately work to get a balance here at the end of the day. And as I said to the administrator, we've got to end the lowballing. We've got to live by the law. If policyholders have to live by the law, so does FEMA. We've got to have the data that drives us, and we have to have flood insurance advocates, as you suggest, being able to make the case along with established institutions like legal services. And I hope the industry and I appreciate your offer, and I'm happy to take you up on it. I hope the industry is willing to work with us to get this right, because I do agree that the industry reputation is at stake. And while FEMA takes a fair share of the brunt, the other reality is an industry that has to do the right thing and has to stand up for its policyholders and has to ultimately, legitimately argue back with FEMA when they are overarching. And I think that maybe you're in a disproportionate set of circumstances where you feel you can't do that. But if you're going to have companies that write these policies, we got to get a just result for these policyholders. So we look forward to working with you on that. Well, you've been very helpful in helping us fill out the record here and understanding some of the challenges. This hearing's record will remain open to the close of business tomorrow. And with the thanks of the committee, this hearing is adjourned.